Hello and welcome to tonight's event, an interview with Philip J. Hirschkop about his life and career as a civil rights lawyer. Before we begin, I want to remind the audience that there will be an opportunity for audience questions during tonight's program. If you have a question, please feel free to put it in the chat box or the Q&A box at any time. Now I would like to take a moment to introduce tonight's guest. Philip Hirschkop is a local Virginian lawyer who has worked on civil rights cases ranging from interracial marriage to freedom of speech and everything in between. He was born in New York and served as a Green Beret and attended Georgetown University Law Center. Over the course of his career, he has worked in the U.S. Patent Office, in the Congressional Office of Richard I. Cord, as an adjunct professor of law and later as a professorial lecturer for Georgetown, and has worked as a private practice attorney. While many may think of his most notable case as the 1967 Loving v. Virginia case, in which the U.S. Supreme Court unanimously voided all miscegenation laws in the United States, Hirschkop has had a long career filled with many other important verdicts. Listing them all would take all night, but some notable cases include Kristen v. University of Virginia, which voided discrimination against women for administration to the University of Virginia and most other universities and colleges in the Commonwealth. Cohen v. Chesterfield County, in which the U.S. Supreme Court abolished teacher maternity leave policies as illegal sex discrimination. Collins v. Straight Inc., in which a jury ruled against a drug rehabilitation program where people were imprisoned against their will without court commitments for months at a time. Landman v. Royster, one of the first statewide class action lawsuits against a prison system establishing due process rights for prisoners in federal litigation. Mason v. Payton, which successfully caused the desegregation of the entire Virginia prison system, and Cole v. Rezzer, in which the leader of the American Nazi Party won the right to be buried in a national cemetery as a U.S. veteran. Hirschkop also notably tried Hirschkop also notably tried a number of demonstration cases, including several major cases, principally in the District of Columbia, on the rights of demonstrators to demonstrate in and around public buildings and on public lands. There are many, many, many more cases I could go on and on about, but without further ado, let's talk to the man himself about his career. Please join me in welcoming Philip Hirschkop. Hi.
Hi.
How are you doing tonight?
I'm fine, thank you.
Thank you so much for taking the time to join our little library audience tonight and for answering our questions. My first one is a pretty general one. What led you to the law and why did you become a lawyer? Was this always what you wanted to do with your life?
No, it was purely serendipitous. I was at Columbia in New York. I got my liberal arts degree there, and I was getting my Bachelor of Science in Mechanical Engineering. I didn't know what I wanted to do, but I did not want to be an engineer, turns out, after getting my engineering degree. I was walking across campus. I was an ex-Green Beret then. I'd been in the military before I went to college, and actually started college as a music major. I was walking across campus one day, short of graduation, and I ran into my advisor. I had never met him or spoken with him before. He was a internationally known history professor, Professor Shenton, and sat down, introduced myself. We sat on campus and chatted for a few minutes, and he asked what I was going to do, and I said, I didn't know. He said, they were giving the law boards next week. Why don't I take the law boards? So I took the law boards. I got like 99% or something. Said, okay, I'll go to law school. I'll be a patent lawyer. And that's how I ended up in law school. And I worked in the U.S. Patent Office and went to night school at Georgetown for the first 2 years of my legal education.
How did you get from patent lawyer to loving?
Also very serendipitous. Then in my second year, it was summertime, 1963. That was a very momentous year. It's the year the 4 girls were bombed in Birmingham, the year Kennedy was assassinated, but the year that they first proposed the Civil Rights Act, which was passed 1964. I was going to night school and I was on my way to campus one night. My wife was away. I'd been married several years by that point, but we hadn't been apart, and she was at a family reunion. And I ran into my con law professor on the street. And that was the day that President Kennedy had a meeting at the White House of African American and white lawyers from the South, basically, to see if they can try and bring some peace out of what was happening, particularly in response to the bombing in Birmingham. And it was a party that night at Hotel Washington for the African American lawyers. And my con law professor, I didn't even know my name. I would sit in the back of the class and read the newspaper. You know, I was a little older than a number of the other students. And he invited me to this party. So I went to the party. My wife wasn't home, and I met some rather renowned civil rights lawyers there. And the next day, on a lark, I went to the Justice Department with one of those lawyers. We flew to Danville, Virginia, which had among the worst mass beatings in history of the South. A lot of people don't realize it was second capital of the Confederacy. And when I saw what happened, I came home within 2 weeks. I quit the U.S. Patent Office and decided I want to be a civil rights lawyer.
So many people do know you from the Loving case, but you have worked for several organizations serving a wide variety of causes, including animal rights, prison reform, civil liberties, and student organizing, just to name a few. Can you talk about some of the causes you have championed over your career? What were some of your favorite causes or cases to work on, and why?
Well, causes would be animal rights. I was outside general counsel to PETA from their inception over 40 years ago till just about 6-8 months ago when I fully retired. Get into my mid 80s, I thought it was trying cases was a bit strenuous now. I love the work with them. The people were just marvelous. They care about animals and they extend that to people. And a lot of the cases for them were remarkable cases. Some were very lengthy and dealt with a lot of issues that you get cognizant of how ignorant we really are of what's going on around us in eating our fellow creatures and killing our fellow creatures and wearing their furs and whatever. So that was probably the favorite of it. My favorite case was the Kirstein case, getting women into the University of Virginia because of what occurred during the case. And there again, once you start doing discovery, you may think you know a lot about civil rights, civil liberties. I had to discover how really ignorant I was of the horrible plight of women in education in the United States. I did a lot of work in penal reform. I was one of the co-founders of the National Prison Project, which were most of the major prison reform in the last 40, 50 years. But it's not something you enjoy. You get satisfaction out of making major change. I did a lot of work on teacher rights, and I was actually hired by the National Education Association in my first 3 years of practice to represent the Duchesne Fund, which is their civil rights fund. And those are just some of the things. And lastly, the peace movement. I took off many months from practice. At one point, I took 4 whole months off and just living basically in the streets downtown during May Day. But I was chief counsel to the peace movement, more or less. I represented May Day, the moratorium, the mobilization, the new mobilization. I had my own police cruiser. I'd negotiate permits with John Dean at the executive mansion. It was a busy, interesting time.
So we've touched briefly on your time as a Green Beret, and you just talked about the peace movement. I want to ask, so you served in the United States military as a Green Beret in the 1950s, and later you went on to act as counsel to several organizations to protesting the war in Vietnam, including Mobilization, Mayday Collective, NCPC, Women's Strike for Peace, and others. Did your time in the military influence you? How did that impact your career?
Well, it impacted my career in a way you wouldn't know. Being in the Army is an interesting experience. I was someone who needed to go in the Army. I was 17 years old. I couldn't get admitted to any colleges. I got into a small country high school. My principal wouldn't recommend me, and he told me, go in the army, straighten your life out, and uh, get a hold of yourself. And you learn in the army to deal with things. You learn to deal with to bitch a little when something's bothering you, and get it out of your soul. And I had learned from my parents a very strong work ethic, which is probably more responsible for any success I had than anything else. Um, but the army affected me that way. You develop an attitude. It can be bad, it can be good. It had a very good effect on me. And I was very proud of that service. My father was an illegal alien, came here from England. He was illegally here for 30 years. And my parents dearly loved this country. They thanked it for opening it up to them. And so many of our relatives, Jewish relatives, came in from oppressed areas of Europe. But as terms of the work I did, other than that personality thing, the army didn't affect it at all. It gave me some credence in the peace movement because people who didn't agree with us called us communists and all sorts of names. And especially when I was in the Deep South, they didn't like Jews, they didn't like blacks, a lot of the people we were dealing with. And they decided if you were either, you also had to be a communist. Remember, they kept accusing Martin Luther King of being a communist. So the military did not affect my career, but it affected my personal life.
So more about the protests. Last year, I had the great pleasure of hosting journalist Lawrence Roberts as he talked about his book, May Day, 1971. And during that talk, he described May Day as the largest act of civil disobedience in United States history. What role do lawyers such as yourself play in these types of movements? Would you consider yourself an activist when you take on cases such as the demonstration cases you helped with?
Well, you could or you could not be an activist, depending on how you approach it. I saw a lot of lawyers who served their client well, who represented their client, but they just represented their client. I chose to represent more than the individual client, the organizations. So it meant taking part in the planning because I had to tell them what was legal, what wasn't legal, what they could do, what they couldn't do. During the demonstrations, a lot of things happen that you don't anticipate when you're out in the street. And having my own cruiser, my own radios we got from Secret Service, they gave it to us so they could keep track of us. You learn to deal with things in the street as they change. The traditional lawyer wouldn't be there. The activist lawyer is there and helping to formulate what's happening. I could do it because the groups I represented engaged in peaceful protest. If they were planning felonies, things like that, I would not have further participated. Nothing I saw merited that. So I guess I was an activist in that regard.
Norman Mailer wrote you into one of his novels, Armies of the Night, where he described you thusly. He did not believe many of the more pious sentiments he was obligated to express. What he did believe was his love of law as an intricate, deceptive, smashing, driving, tricky, somewhat game somewhere between wrestling, football, and philosophy. What also stood out was his love of winning, his detestation of defeat. So when you're trying these cases, such as the ones involving the protesters, is it about winning a game like he describes in that paragraph, or does the subject of the case play a role in your enjoyment of practicing the law? In other words, would you have just as enthusiastically prosecuted Norman Mailer as you would defend Norman Mailer for protesting at the Pentagon?
Well, the answer to that question is no. uh, it's hard to put your finger on it. Again, going back to being an activist lawyer, I loved what I did. And what I did was represent underdogs who I felt were being wrongfully attacked. In the Loving case, for instance, this was a couple who just wanted to get married and live their lives. And there was no earthly reason why they couldn't do that. There were terrible excuses being given by the Commonwealth, and it was just the act of perpetuating slavery or the badges of slavery or whatever. And the same when you look at all the other cases, women at the University of Virginia, I saw young women who were totally being denied an education solely because of these crazy reasons. And when I took the discovery, or the lawyers with me in the case, John from I can't remember John's last name, from Charlottesville, uh, John Lowe. We were given the crazy excuses that women couldn't go to UVA because they couldn't live in the men's dorms because they were wall hung urinals. We suggested they should plant geraniums in the wall hung urinals, and there's a self watering system then. That women couldn't go to, that women had to be at Mary Washington because they needed gowns and things so they can go out at night. So they needed more closet space in their dorms. That women couldn't live in dorms, male dorms at Virginia Tech because they need diminutive furniture, and they needed kitchenettes because women need iron at night. With all this crap that we were given by very notable educators, we found the average entrance score for a woman was 100 points higher than a man. That is a massive difference back then. And we found repeatedly women were pushed into Radford College, the college Longview down in Prince Edward County, and a couple other colleges, which are good colleges. They are basically teacher colleges, and not where you start your career as a lawyer, a doctor, a physicist, all the other things that a more advanced education can lead you to, or just the privilege of more advanced litigation. So things like that, they were very enjoyable, and I participated and I enjoyed them, and you get to be happy when you win cases like that. But it wasn't a matter of winning or losing. It was a matter of protecting the people I represented. When I did personal injury, I did major personal injury cases. I didn't do most car injury cases. People who are severely injured because of horrible corporate policies, or people putting greed ahead of the safety of the personnel that are out there in the world. And when you lose something like that, it's not winning or losing. It's not protecting the people against the odious treatment they were getting.
Then I have to ask about, and I'm so sorry, I'm going to say these names incorrectly, but Cole v. Rezzer, which was the case you tried in which the leader of the American Nazi Party wanted to be buried in a national cemetery as a veteran. Can you speak more about that case?
Only with difficulty. I laugh now, but that was the saddest experience of my legal career. My parents were Orthodox Jews. It changed after my mother had cancer treatment and could no longer do some of the things in this little town we lived in central New Jersey. The guy who headed the Nazi party there, George Lincoln Rockwell, was assassinated in Arlington. He was an ex-lieutenant commander in the Navy during a time of war and was qualified to be buried in a federal cemetery. And so they made arrangements to bury him in Culpeper Cemetery, which is a federal cemetery. When they got there, they were wearing the uniform with SWAT stickers on the armbands, and so were not allowed in the cemetery by the marshals. They then appealed to the ACLU for help. The ACLU couldn't get anyone to handle the case. I was one of the founders of the ACLU of Virginia, and I served on the national board of the ACLU for almost 20 years. And so they came to me, and I said, I'm not going to represent Nazis. I refused to set foot in German soil my whole life, and although I've traveled greatly. And I really hate Nazis. And they said, well, we're your principals, because who's going to represent if you don't? Because if they can stop someone from wearing a SWAT sticker, then they can stop me from wearing a Jewish star. They can stop others from wearing a cross. They can stop people from wearing an elephant or a donkey. But all the signs, it couldn't be pure free speech. There was no danger to anyone out in Culpeper. No one cares who's running around the cemetery with a SWAT sticker on. And so I filed suit, and it was a nightmare. Went to court before a rather strange federal judge. We called him Roaring Oren, but he was a difficult judge here in Alexandria. And I put a client on the stand, the guy who was head of the party at that time, And the judge said, get him off the stand. I don't want to hear from him. I read about it in the newspaper. Not proper, but, and he referred to me and my friend the Nazis. And I said, Judge Lewis, I'm here to bury Rockwell, not to praise him. I paraphrased William Shakespeare on that. And I'm sorry to this day that I did, because the next day there was an article in the Miami Herald with that quote. And there's a knock on my mother and father's door. And my mother's closest friend came and asked her if her son represents Nazis. My mother called me up and I said, please, Mom, let me explain. She handed the phone to my father. Same thing happened, and they didn't speak to me for 2 years. It was a terrible point in my life.
That's very hard. I have a question from an audience member, Mike, and he actually wrote in prior to tonight's talk about this case, specifically because the ACLU has recently been rethinking the way it deals with freedom of speech cases that involve hate speech, not necessarily wanting to take on some of the more heinous cases that they may have taken on in years past. Do you have thoughts or opinions on this? If you were trying that case today, would you have taken it?
If there was no one else to take it, I would do it again. It couldn't be pure speech. When you start giving it in and choosing that symbol, there are a lot of symbols we don't like. There are a lot of symbols we see from the people who raided the Congress in last year, how they object to symbols of the Democratic Party or other symbols. And if they're in power, they could ban those symbols, or we could ban their symbols. A lot of them are wearing military patches that they earned. Speech is the main thing that ties us together as a free democratic society. The ability to speak and the ability to hear and to learn.
So speaking of banning symbols and learning, this is Banned Books Week. So Banned Books Week runs end of September. I think the last day is tomorrow. And you actually tried a case, and again, I'm sorry, I'm going to butcher these pronunciations, but Rip Kema v. the Board of Education. It was a case in West Virginia dealing with protecting the right of teachers to assign classroom materials and books to students with reasonable academic freedom. And I think this is especially noteworthy because this week, which is Banned Books Week, Fairfax County Public Schools has pulled 2 books from their shelves over parental concerns. So my question to you is, can you speak more about that case? What was going on, and what were the teachers trying to do that the Board of Education objected to, and what rights were the teachers seeking in that case?
Well, that was a case where a progressive teacher assigned, it was called the Little Red School Book, I think. If that was the problem. It was a red school book, well, it was a big red school book or Little Red School Book. It came, I believe, from Denmark when the Danish, that area of the country, are more liberal in how they teach, and it had references to sex in it and things like that, but it was highly recognized by teaching organizations. I was asked to go out by the National Education Association to go out and represent this teacher out there, and we filed suit in federal court. Interestingly enough, I then took the depositions, take testimony from the defendants, the school's Board of Education. And I started asking them from various books, would you ban this, ban that? Every one of them would have banned the Bible, because I didn't tell them it was the Bible, but I read them passages from the Bible which are very explicit about sex and, things that you otherwise wouldn't. And I asked them major things, especially from Shakespeare and the Taming of the Shrew. And they'd have banned most of Shakespeare. They'd have banned the Bible. They'd have banned all of Kurt Vonnegut and on down the line. It's a terrible thing. But it's interesting for today's society. There's a real problem about, when we're removing all these statues, we're removing flags, we're removing things. Some should be removed. They certainly are irritating. They certainly don't represent how a lot of us feel right now. And they are very irritating to minority people. On the other hand, a number of parts of our history, and banning our history is a mistake. At some point, do we get close to the Taliban when they were tearing down those huge statues of Buddha? those statues of Buddha as obnoxious to the Taliban as, General Lee might be to people in some people in Richmond. So when you start taking down symbols, it's a very dangerous precedent, and banning books is among the worst parts of it. I still remember all the films I saw when I was a kid in Nazi Germany of throwing the books into big bonfires and closing people's ability to know is shutting off speech, because there's no use being able to talk if you can't hear.
Let's go back in time a little bit to the 60s. Early in your career, you served in the office of Congressman Richard Icord, who voted in favor of the Civil Rights Act of 1964. Did you have an opportunity to do any work on any piece of legislation, including that one? And what was it like working on the Hill during such a turbulent and momentous time in American history?
It was one of the great failures of my life. Dick Icord was from middle Missouri. He was a middle of the road, I thought, congressman. When you go to law school in DC, you get Hill fever. Most law students want to get a job up on the Hill while they're in law school, because you run into a lot of people in law school who are working on the Hill. It's a big part of it. And a close, dear friend of mine worked for Congressman Montoya, later became Senator Montoya from New Mexico. And I said the congressman in the office next to Montoya's was on Interior and Insular Affairs Committee, and he was looking for a legislative aide. I had just decided to become a civil rights lawyer, so I resigned from I transferred from night school to day school, and I needed a job. My wife was teaching, but we needed the money. I had no other money other than my GI Bill for a while in college. And I went to work for him, and the first thing he asked me to do was write an article on the House Un-American Activities Committee. What I didn't realize is he had gone from Interior and Insular Affairs to House Un-American Activities Committee. So I wrote the article, and he called me in. He asked me if I was a communist, because it was truthful about the House Un-American Activities Committee and what a horror they are to American society. And I remember people coming in, his administrative assistants, saying, well, the American Civil Liberties Union, they're communists, they're on the Attorney General's list, which isn't at all true. She'd mistaken him for another group with a similar name. So we agreed I would work home for a while. And I did. Actually, I took the records from the National Lawyers Guild from the House Un-American Activities Committee, and I sent them to the Guild because I knew a lot of Guild lawyers who were doing a lot of fine work in civil rights, civil liberties. So that didn't turn out too well. I ended up 4 months in the Hill. He finally called me one day, most of it working from my home, and said, maybe we should go our own ways, Phil, and we separated. The next time I saw that congressman, I appeared up on the Hill at a House Un-American Activities hearing where they subpoenaed in leaders of the peace demonstration. And I went up to say hello to him, and he pretended he didn't know who I was. He had just finished telling Congressman Alsbrook from Ohio, who I'd been on a debate with a couple of weeks before that, who I was exactly. But it's not a great experience, my employment on the Hill, for either side, me or the Hill.
A couple different audience members wrote in with the same question. So thank you, Elizabeth, and thank you, Lindy. Both of them are wondering, so compared to your work in the 1960s, compared to today, do you think that civil rights is still something that there are people who are passionate in the law about? And what are some of the major civil rights issues that we're dealing with today?
Well, same-sex marriage is one, although it is accepted now. The Supreme Court narrowly let it go through. I don't know what this new bunch, some of the new members of the Supreme Court, whether they will allow that to stand. Certainly the sanctity of Roe v. Wade is very much, the woman's right to control her own body is very much in control now. Transgender people, how to treat them. And then the whole Black rights movement, Black Rights Matter, is very difficult. There are some parts that are clearly demand change in our society, and some that are overstated and would cause more problems than if we pursued them. But clearly prejudice and discrimination are inherently the things most need to be dealt with in our society. Being a melting pot like we are breeds the problem of then all the different elements coming in. The Hispanics coming in from Central America, it's a very powerful movement in the United States. It's causing a lot of fear and trepidation, apparently, among a lot of, especially Midwest white people and Southern. The African American movement, the treatment of police, I personally differ greatly with the black rights, which I back, but position on police. There's no question of systemic prejudice among the police. But when we sued the original prison cases, we found out that a great many of the employees, a large majority it seemed, were white people from southwestern Virginia. This is in the Virginia prison system, or West Virginia, and they were brutal to black people. At that point, it was open discrimination in the prison system. No one cared about it. And yet we got a fine federal judge, Judge Robert Marriage in Richmond, brought a case for him that was the first statewide class action case for reform of a prison system. And when he entered strict orders, these same people with their prejudice were able to do their jobs fine. As long as they knew there was someone looking over their shoulder and say, these are the rules, this I have to do it. It don't make it perfect, but it's the better start. Where we have now is that it isn't so much prejudice that is our problem with police forces. It's the lack of ability to force them to tell the truth. It's the blue line is the main problem we have. If you look in Virginia, some of the worst problems we have by police, for instance, up here in Fairfax County, is they shot a guy who was standing in his doorway. He wasn't doing anything up in Rose Hill. And he had his arms up, and some cop came on the scene. There were all cops in the lawn. They'd been talked to, and he shot him and killed him. He was a white man. A guy got out of his car, came from his house to pay a bet because they'd had a poker game at his house to an undercover police officer. And a cop a few doors down jumped out and shot him and killed him. He was a white man. And we've seen that a lot of white men are getting killed too. The problem is the police get away with it because they won't testify against each other. They're afraid to, because then the other cops prejudice them. We have to cure the blue line. That's the biggest problem. Prejudice we take care of. I mean, we'll never get rid of prejudice. People are born different colors, different races, different religions, and they tend to prefer their own. That's natural. You don't want to ride in a bus with somebody. I don't think it's that healthy, but fine, walk. You just can't tell someone else they can't ride on that bus. So it's a major problem. Race will always be a difficult problem in this country because we are a big melting pot.
Lindy follows up with that question to ask, do you think there's still a passion for civil rights law in the legal profession? Are young lawyers choosing to pursue this?
Yes. I used to get a lot of calls. One of the early things I did when I was in Danville, Virginia, is I got with other law students. We formed the Law Student Civil Rights Research Council. So in 1964, we had formed the council. We supplied all the law clerks and paralegals to the civil rights officers across the South. The summer of 1964, I spent most summer in Mississippi. This is when some of the three boys were killed down there and buried under that dam. They weren't boys, they were young men. But a lot of students would come to me after that because of my experience with law students. What should I do now? How can I do it? I don't get as many calls anymore because I'm not as active as I was. But I see from people going to law school, there's a very genuine interest to do civil rights and civil liberties work. And they say, how do I do it? And the way you do it is not by talking about it, but pick out something you're interested in. It's women's rights, it's conservative rights, whatever. Find organizations that propose changes, that propose protecting people, and go do volunteer work for them. There's plenty out there that need help, both in the transgender community and even in the conservative community. Something I'm opposed to, but part of a democratic society, I welcome their presence.
I want to switch lanes a little bit and talk about another case that you've tried. So you've tried many cases where you defended people and organizations against government surveillance or overstepping. For example, United States v. Hubbard dealt with government search and seizure. Collins v. Straight Inc. dealt with people being imprisoned without court commitments. And United States v. Bass dealt with wiretapping. Can you talk about how you view the role of government in our lives? What would you say that lawyers such as yourself play a role in checking government power?
Absolutely. I am in favor of more government in our lives as opposed to other people of it. And you look at the introduction to one of the most famous things, we hold these truths to be self-evident. All men are created equal. They are endowed by the Creator with certain inalienable rights. Among these, life, liberty, and the pursuit of happiness, that in order to protect these rights, governments are instituted among men. In the very introduction to the things that grant us all our powers that we're so proud of in our own Constitution, it points out that the government is the necessary element to enforce and coalesce in enforcing our rights. And I believe in that very strongly. I myself, think, however, that unless you have some prescription, unless you have some checks and balances on government, it will run away. It will. If you give a cop a club, you send him into a neighborhood and say, we want peace and order, he'll end up beating people. Whether he's a nice liberal guy, he's a conservative guy, a nice liberal lady, a conservative lady, he'll end up beating people with that club unless they wait. But here's the rules how you can use that club. And it's true of government also. So lawyers play a very strong role in that. Just as we see now, you remove the sanctions from banks, and we're going to get another housing crisis. You see what they'll do, because they're in it to make money. They're part of a capitalist society, and without safeguards, it'll run away. It's necessary in every element of government.
So we've talked a little bit about prisoner rights and prisoner reform, but let's touch on it a little bit more. You've written a lot about that topic and you've tried many cases related to the topic. Can you speak more to it? How did you become interested in prisoner rights and prison reform? And given the opportunity, what reforms would you most want to implement?
Shortly after the Loving case, actually the year I argued the Loving case in the Supreme Court, there's a statewide strike at the Virginia penal system, mainly in the penitentiary. The black prisoners said, well, we don't want this anymore. And they started writing to me because there was no ACLU at Virginia. So somehow, I don't know how they got my name. And I had all these letters. So I got some of my neighbors, and we would meet at my house, and because I felt these letters should be answered, and we found some horrible things going on. I remember one guy wrote to us that he was serving a life sentence and he'd never had a lawyer, and it was for burglary or something. He didn't murder anybody, didn't rape anybody, but he was an African-American guy who was not educated and lived out in the Eastern Shore, and we kept coming across stuff like that. It was terrible discrimination, and then we start seeing how the prison system is run. Virginia, if someone wrote to the ACLU or to a lawyer to get relief, the guy down at the penitentiary there, he hung them from the bars by their hands so their toes touch the floor. They could be like that for 3 days, standing in their own excrement and urinating down their legs and getting bread and water. Wasn't as bad as some of the other prisons, Parchment and some of the others from Mississippi and Louisiana, where they had a electric ring phone that they hooked up to people's testicles. But that was the United States. Our prison systems were horrible. So first we had to deal with the extreme violence in the prison system. Then you have to deal with the whole reason for a prison system. We would mix in youthful prisoners with adult prisoners, and there was no way you're going to get that youth back reformed. You're just going to get someone back who's trained in greater criminality and violence and learning that you have to do certain things that really aren't acceptable in order of society to exist. So we have to look at why have prisons. Why does the United States have more people in prison than anyone else? Probably more than Russia per capita, or places that are terrible treatment of their own people. So, and the prison should be a holding place to keep people out of society who don't fit in society, to try and have some way to reform them. We've learned that some things don't really cotton to reform very well. Certain types of crimes have high recidivist rates. On the other hand, we don't look at what caused them to be in prison to begin with. The whole problem here, like reparations, isn't that good an idea if it's just giving people money that they're going to blow on something. A lot of people use it for food. Some people use it to buy drugs. But if we did reparations to people who we've deprived in the past to cure the economic problem, which is what fosters crime. A person doesn't go in a dark house with a gun and commit a burglary for a kick. It's dangerous, it's terrifying, but they may not have a job. They may not have money. They may have learned that's the only way to do it wrongfully. The giving drugs and selling drugs. We have to deal with the financial incentive. So we should have affirmative action. We should see that the people who we've disenfranchised, the African American people, the Hispanic people, the Native American people, are given greater opportunity to education and the ability to earn and the ability to have a stable family. Doing that will cut crime. Cutting crime will cut prisons, and prisons should treat the people they're dealing with rather than just lock them away and behind stone walls and make them worse than when they came in.
We have a question from an audience member, Osei, about the prison work that you've done. Osei writes, in the past, you used to serve as executive director of the penal reform. The Bureau of Justice Statistics estimates total spending on prisons and jails to be approximately $50 billion. Having said that, do you think taxpayers need to pay for building more prisons and jails to accommodate over 2 million inmates in the United States?
No, we need fewer inmates, not more prisons. When I started practicing, we were locking people up. I remember one young man got 20 years for passing a joint to somebody down in Martinsville, Virginia. I saw too many young men, young women, particularly men though in those days, going in for because they smoked a joint, they possessed a little marijuana, they did things that they weren't criminal. Well, of course, it was criminal to get married to someone who wasn't the same race. There were crazy laws. We had a law in Virginia that a thrice convicted felon could not marry a woman under the age of 45. They didn't repeal that law until about 20 years ago. Well, there was an old Buck v. Bell case in the U.S. Supreme Court that 3 generations of idiots are enough, so you can sterilize people. But those are old concepts that hopefully aren't at all. Well, we know they're not dominant anymore, but hopefully they're not even that proficient. So it's just taking a better look at who we prosecute and how we prosecute them and why we prosecute them, and we'll need much less in the way of prisons.
Lindy has written in with a question. Lindy writes, I read you represented Mitch Schneider, who is a DC homeless advocate. What was that case about?
Well, I met Mitch when I represented the Berrigan brothers in my peace action work. And then he formed the homeless shelters and became head of that group. I read until he became fairly famous, and then a number of the big firms, Covington, Burling, others stepped in and said, we will represent you. And they clearly could provide more and better services than I could as an individual lawyer. He was difficult to represent, as were the Berrigans. They were likable personally, but you couldn't reason with them. At one point, Mitch went on a hunger strike against a church in Georgetown that Edward Bennett Williams belonged to. So they're putting a new roof on, although the old roof seemed okay to him. And that money could have fed myriad people. He felt that was a wrong expenditure. I mean, he was very Catholic, as were a lot of the people with the Berrigans. And I remember when he was near death. He was passing away. He was sitting in the courtyard. There was a big article about him in Washington Post. You see he's sitting next to a hedge. You see there's a face in the hedge. And I was the face in the hedge. I was trying to convince him to take some water and eat. He was killing himself. He came very close. We came close to losing him. But it was very difficult representing very, very committed people. They don't think like we think. They are willing to make sacrifices we are not willing to make, and very often we don't understand. But I'm very proud of having represented him because he did wonderful things for people that otherwise couldn't have got that help.
A couple different audience members have written in about topics that they're curious what your thoughts are on them. So the first comes from Robert, who writes, would you consider taking on the draconian measures aimed at sex offenders through the sex offender registry? These seem to be clearly unconstitutional. There are millions of people affected by the registry, both the registrants and their wives and children. Do you consider that to be a civil rights issue? What are your thoughts on that topic?
It's clearly a civil rights issue. What has happened is so much else in our society. We had a problem. We saw in the Catholic Church, it went unchecked for God knows how long, how many youngsters were abused by it, but not just the Catholic Church. It was something society hadn't dealt with a lot while they're dealing with other problems. But then our response overdoes it. So whether or not a registry is any good to begin with, unquestionably, it is overbroad. People are put on that registry who just don't belong there. On the other hand, it is protective, and it's always about civil rights, civil liberties, are always a balancing act. The rights of society versus the right of the individual. We see it now in vaccinations. A person, if they don't want to get vaccinated, shouldn't be forced to be vaccinated if they're willing to live in their house. But if they're going to go out in society and mix with other people, particularly kids, then there should be an absolute right for society to say, we demand this of you to join. I mean, we make people get a license to drive a car. They get a license to give a haircut. And there's a history of ordering vaccinations. Well, it's the same way with the sex registries. We've overburdened it, and too often it's used as a form of punishment. It should only be a form of notice to people around them in society that here's someone who may have this proclivity and you can protect yourself. But on the other hand, the right of that individual to live free in a society is impeded. And you have to weigh one against the other. And sometimes there is no good answer.
Elizabeth writes in with a similar question about age discrimination. Do you think age discrimination is a legal or civil rights matter at this point in time, or do you think it could become one in the future? Do you have thoughts about the types of cases that might come up in this area?
Well, age discrimination very clearly is a civil rights, civil liberties issue. We have an act that goes to it. Very clearly, there's prejudice against older people. And again, sometimes we get to the response maybe too much, but it's clearly a civil liberties, civil rights issue that when you get old, things change. You can only deal with certain things. Your health changes, your ability to walk, your ability to eat, your ability to get along with people. You get cantankerous. You can't work anymore very often, and it's living. Churchill talked about how rating a society, how it takes care of its aged and its prisoners and its children and whatever. And that's how you have to judge our democratic society. We should provide health care to our poor people and our sick people, and we should provide the needs to our elderly people who helped get us where we are. A lot of these people are people who fought the Second World War, and I was a Korean veteran. The Korean War and the Vietnam War and the Iraq War and Afghanistan, and they age and they get old, and sometimes they get old more quickly because of the experiences in war. And we do to take care of them, but whether they fought for the country or just lived here and worked at the local grocery or whatever, we have an obligation in a decent democratic society to care for our infirm and our aged and our others who deserve that help.
Ashley has written in to ask, have you ever written any books about your life or experiences, or do you have books on these topics that you would recommend?
No. I'm laughing because my kids have really been after me to do that and a lot. I am actually in a process now that I've stopped trying cases in the last year of taking the major files. I've made a commitment to donate them to a charitable foundation where they can be put in decent order and then given to the Library of Congress. The library's been after me to get a number of files, the Loving file, a lot of the peace demonstration files, the file with the women in the University of Virginia, the Cohen file in the Supreme Court on pregnant teachers, and a number of others. Now, you mentioned Larry from the Washington Post was here for a year, coming to my house and writing a book on the peace demonstrations, and I had 12 boxes that the original documents, they were the original permits with my handwritten notes of my conversation with John Dean and with Kleindienst and Chief Wilson, and correspondence between me and Spiro Agnew about use of the West Lawn for the first demonstration there ever. And they're very unique, but I don't want to write. I had the privilege or pleasure, or maybe, I don't know, of meeting Louis Nizer, who's a great trial lawyer, who wrote My Life in Court. And it's about, he was a great lawyer and about interesting cases, but it's a big ego trip. My ego doesn't demand it. You know, when you win some of the more notorious cases, like I've won some of the more popular cases, there's press conferences afterwards and there's a lot of recognition awards. I try to avoid all that. The best time when you win a really good case is the next morning. Well, it's two best times. The next morning when you shave, there's no one there. You look yourself in the eye and you say, I did good. It's a feeling I can't, it's better than any press conference. It's better than seeing your face on bloody TV or the New York Times, or the Washington Post. And sometimes I sit here at my desk and I have one picture on my desk. There's two now because one of my old dogs passed away and his is there. It's a picture of my father and I at the U.S. Supreme Court on the day I argued Loving v. Virginia. And for so often, people come to me when their rights are in danger and their lives are very much in flux and ask, what should I do? And I don't always know the answer. We had a statement in the Army, no mommy, no daddy, no first sergeant. You got to decide yourself. And you don't know what's right or wrong. And I look at the picture of me and my pop and I talk to my pop and say, hey, Pop, is that the right thing to do? So there's a quiet pleasure in those cases. But for posterity, I'll put the files in order, but I won't write a book because it's just too big an ego trip.
Well, I appreciate that you were willing to talk to our audience tonight. I hope it wasn't as big of an ego trip as a book would be, but thank you for that. We still have a little bit of time, so I have a couple more questions for you. So we've talked a lot tonight about Kristen v. University of Virginia. And I was just wondering, so that was the case which paved the way for women to be admitted to universities across Virginia. What was the scope of that case? Was that limited to Virginian universities and colleges, or did that have a wider effect on the greater United States? Where did Virginia fit in at the time with other states?
Well, it was the first case of its kind for women in higher education, and it was part of a developing movement. By then, Chapel Hill, University of North Carolina, had gone co-ed. Princeton had announced co-ed. Yale was going that way. My own school, Columbia, hadn't decided yet. It was an all-male college, but it went not long after that. But that was the movement. In the same time, the Civil Rights Commission was trying to decide whether that issue was covered by the act that they were enforcing. And so when I went to try it, we had a great expert witness in it. Katie, I can't remember her last name. It happens when you turn 85, I forget name. But one of the great people in the civil rights, in the women's rights movement. She taught at a Barnard Law School. And She came now testify. I think she was the first female Don at Oxford, and before this three-judge federal court. And it was fascinating to watch her talk and to see how the thing developed. Uh, so I just have to fall back on that case like that as to what guides me and what should guide us and how to deal with those things. It's Kirstein is the name of the case, but Kirstein came to me from John Mann in Charlottesville. He was co-counsel. We shared the case. I had the experience to do that kind of civil rights litigation, especially a three-judge federal court, which he had never done. He developed the facts. He brought the dean of women for the University of Virginia to my office. She was a marvelous woman, is very composed, educated woman, and sat and cried in my office, telling me of the number of young women who came to her who could not get a higher education because of these bizarre rules. And so we did it as a case to affect all universities in Virginia, not VMI. Being that it was military, that raised different problems. So we let that go. And as you probably are aware, it was many years later, finally, that Ruth Bader Ginsburg, an old friend of mine, we were on ACLU National Board together for a number of years, and I was on her board of directors on her women's rights project. Wrote the opinion for the U.S. Supreme Court, knocking that out. But by the time we got through trial, we settled the case. UVA took in, I think, 1,500 women the next year to immediately rectify the problem and start working on it. And it was applied only to the University of Virginia, but the other universities immediately fell in line of Virginia because we had the precedent of the opinion of the three-judge court saying that it is illegal to discriminate that way. And coming from a three-judge court, it was very precedential around the country. So it helped the Civil Rights Commission, and it helped many other universities on a path that a lot were by themselves pursuing at that point. We also filed another case, Paxman versus Virginia, in federal court out of Charlottesville to make it a class action. But by then, so many people, schools were falling in line, that case never got pursued to conclusion.
Well, we are running out of time for tonight, so I only have one last question for you, and that is, what advice would you give to an aspiring lawyer?
Well, it's a good profession. It's great if you retire, you can handle one case a year. You can get a lot of gratification out of the work you do. You can set your hours. Have to learn to work hard. Too many lawyers are lazy. Too many lawyers, the best thing they do is get a continuance because they don't want to deal with it. It's an important part of being a successful lawyer. I've never known a really good lawyer who wasn't a very hard worker or didn't have a great work ethic. Decide what you want to do with it, what you're interested in, and then pursue that. A lot of people think they want to be criminal lawyers until they go out and try it. That's a tough business. You have to be a little hard some days. You have to take a lot of abuse. You have to deal with some clients who you're not going to fall in love with very often. I used to do major criminal cases, and I found myself one day representing some people from South America who were passing cocaine to kids in schoolyards. I said, no, there's plenty of lawyers to do that, not me. So whether it's civil rights law or age law or personal injury law, personal injury, people injured are entitled to be compensated. And the personal injury lawyers have a tremendous benefit to this country. And look at what happened with smoking. That was all a bunch of personal injury lawyers. A lot of people were dying from cancer, and the government wasn't going to deal with it. And the same is true with the auto industry, what Ralph Nader started. Find out what you want to do and then pursue it. Work hard at it, and the rest take care of itself. It's a very opportunistic profession.
Well, thank you so much for joining us tonight. And thank you to the audience for joining us for this program. I think it's great that we have people in the community who want to spend a Thursday evening talking about some of these topics. I want to let everyone know my next program is going to be on Sunday. Local business owner Amy Duval, who owns From Politics to Pastry, is going to join us for Hispanic Heritage Month to teach us how to make tres leches cake in real time. So if you have a sweet tooth or a love of baking, or even if you just really love cake, please join us on Sunday while we bake along in real time and make tres leches cake. Thank you so much for joining us tonight. Phil, do you have any final words for our audience?
No, thank you for the opportunity to speak to you, and I hope it was of some use to people.
Well, thank you so much. Have a good night, everyone.
Good night.